It's also a pleasure and honor to have you as the chair of our panel. It's great to meet you. And of course, big thanks to the organizers and Laszlo in particular for getting me, it's my pleasure, involved in this fantastic organization. So it's a pleasure to be here. It's also my first time in Budapest, so I cannot imagine a better occasion to visit this beautiful city and country for the first time. So actually, Laszlo has made a very good introduction to, I think, all presentations, but in particular, it works great for my presentation since I will be speaking about Luxembourg, and you have already given a little bit of context as to why Luxembourg is one way or another notable in the field of space law. But maybe before I talk about what Luxembourg has done, another thing that I can talk about why it has done what it has done. I think this is an important starting point, because Luxembourg, by all measures and metrics, it's a tiny country. It's very small. It's from one end to the other. It's about 70 kilometers north and south. It has a population of 650,000 people, roughly 1/3 of the population of Budapest, according to Wikipedia. But it has historically proven to be a very resilient, persistent country, stuck between arguably some of the greatest powers in Europe. And in the, let's say, modern history, in the 20th century, it has also become one of the founding members of the European Union. It sits really at the heart of the very raison d'etre of the European Union, which is the coal and steel cooperation and the resource interdependency. And south of Luxembourg is well known for its coal and steel operations, at least it used to. So it was very much at the heart of political consolidation in Europe from the outset in the modern history. And it's been invaded by the various nations. At some point, even Austrians controlled it. But it somehow persevered, and it has struggled throughout its history to find distinct ways to exist and distinct ways to sort of further its existence. One of them, as I said, was the promotion of this coal and steel industry, but as that boom started to fade out towards the 70s, the policymaking has turned its attention towards developing a financial sector, which is possibly one of the most robust in Europe, if not the world. It's one of the wealthiest countries in the world, and its financial sector is going very strong. As we move on to the 80s, slowly we see that this developing financial sector being complemented by an emergent space sector. This has begun very much with the emphasis on the telecommunications. In 1985, the Société Européenne des Satellites, SES Europe, as it's known today, was established. It's a Luxembourgish company established by Luxembourgers, and it's now it's one of the biggest telecommunication satellite operators in the world, certainly in Europe. And as we sort of move on, maybe towards the 21st century, into the 21st century, we then see an emphasis sort of building up on the commercial uses of our space. And this is a trending subject, of course, globally. And Luxembourg sort of managed to catch that wave, and it's currently riding it quite well. The commercialization, the new space phenomenon, are obviously very timely discussions, and in Luxembourg we see that manifesting in very various ways. So there is a very articulate, very multi-layered space policy, space promotion ongoing in Luxembourg right now, which is evidenced by hundreds of established companies, legacy companies, newer companies that prove to be very successful, newer companies, startups, very cutting edge, smaller companies with very cutting edge activities. It's possible to see all these different actors in Luxembourg today. iSpace, as maybe you know, it's fundamentally a logistics company. It's a Japanese company, but it's also one of the first companies that aspire to be one of the first commercial entities to land a rover on the moon and operate on the moon. One final thing to say as an overview is that there's a big emphasis in Luxembourg on the use and exploitation, not exploitation, maybe that's the correct word, utilization and exploration of space resources. And this is also a very articulated, clearly articulated state priority. This being the very general introduction, space law in Luxembourg, we can generally speak about two segments. Let's say international law. Laszlo already talked about what they are, and seeing the audience, you all know what these treaties are, so I'm not going to go into that. So it's a party to the Outer Space Treaty, Liability Convention, Registration Convention, and Rescue Agreement is signed, but it's not yet in force. It will happen fairly soon, I believe, in a year or two. It's not a party to the Moon Agreement, perhaps unsurprisingly. And on the domestic law side, we see a multitude of different laws that regulate space activities. The oldest of those laws is the 1991 law on electronic media. It has seen some amendments along the way, but this is essentially the law that regulates orbital positioning and frequency allocation, very much about satellite operations. And this used to be the legal basis for space activities in general, due to the lack of a specific space activities law, which is no longer the case. Second one, in 2017, there's a law on exploration and use of space resources. I will talk about this law. It's one of the 4 current laws in the world, national laws, besides US, UAE, United Arab Emirates, and Japan. And finally, law of 2020 on space activities. It's a more general law, let's say, when compared to the law of 2017. It covers every space activity except for space resource activities. And I will also talk about them. So I will address all of the laws, but I want to especially emphasize the final 2, 1991 law, for the sake of completeness. I will briefly mention. As I said, it concerns orbital positioning, frequency, band allocation, and the relevant authority, the supervisory authority, is the l'Institut Luxembourgeois de Régulation. It's also an auditing entity, and it's not just about frequency band allocations, but also energy. There are other competences. It's generally it's a general supervisory institution that was established, I believe, 20 or so years ago, 1997 or 1998, something like that. And according to the law, it says no person may transmit a Luxembourg broadcasting service or a non-Luxembourg broadcasting service without having first obtained a license or permission in accordance with the provisions of this law. So as you can see, generally about transmissions, telecommunications, and the license is granted by the government upon recommendation by the ministry, relevant ministry, which is charged with telecommunication and media. Currently, the Minister of Telecommunication is the Minister of Justice. They're the same person. And again, this is one of the things in Luxembourg that's, I suppose, maybe it's about something. It might be common in smaller countries that single ministers sort of fulfill different roles. The Ministry of Justice is also the Minister of Telecommunication, and Minister of Economy can also be the Minister of Defense. You know, they're all consolidated. So Minister of Justice, who is a lawyer, obviously, is also the Minister of Telecommunication. And prior to the 2020 law, it was generally referred as the legal basis for space activities in general. So 2017 law, possibly the most interesting of all laws, all legislation available in Luxembourg. This is a mid-journey AI-generated picture. I just wrote law of 2017 on space resources, and this is what I got. So yeah, it's also the case for 2020 law. So I thought it was a little interesting Easter egg. So this is a fairly new law. Evidently, it's less than 10 years old. It's one of the first of its kind. It's the second law after the 2015 law in the US. And it's the legal basis for the exploration and use of space resources as far as Luxembourgish entities are concerned. So what does this law contain? It generally contains the terms and conditions relevant for the acquisition of a concession, which is the license. It's in the law, it's called a concession, to conduct space resource activities. I think very broadly, we can divide this law in two parts. The first part is only Article 1, which is one sentence that says you can own space resources. And from Article 2 onwards, it's basically the requirements and conditions needed in order to obtain the said concession. What is excluded from the scope of this law are the launch activities and the registration of space objects. And as I said, only space resource activities are relevant to the law, like satellite communication, orbital positioning, frequency allocation, as I said, are not relevant to this law. So the law was, it's essentially the result of a very long period of research and due diligence, if you will, which culminated into a research project in 2015, 2016, which concluded eventually that Luxembourgish national legislation on space resources would not conflict its international obligations. And if you are even tangentially familiar with international space law, you know exactly what conflict and what international obligation this is referring to. Obviously, the non-appropriation of space, outer space. So, as I said, the Article 1 provides, contains arguably the most important, most controversial aspect of this law, which says the space resources are capable of being owned, or this is the original French text. I think the English text isn't necessarily very accurate, let's say, but it says space resources are susceptible for appropriation. They can be owned. This is the current text, the text that is in force. And an interesting anecdote about this sentence is that before it was legislated, before it entered into force, as is the case in Luxembourg, that when the legislative organ drafts a law, this draft goes to the Conseil d'État, which is the advisory body of the legislative organ. So Conseil d'État reads through the draft and then gives an opinion on the legality or the appropriateness of this law. And so was the case in early 2017. Conseil d'État processed this first draft, which said, as opposed to the current version, space resources are capable of being owned in accordance with international law. Something to that effect. I'm paraphrasing, but it's basically what it said. It qualified this capability with in accordance with international law. Conseil d'État took this draft and then they gave an opinion, basically casting doubts on the confidence in the sentence, and said it's not clear to us that this is it's necessarily in accordance with international law, that you drafted this into a law, intend to have this pass as a law, but it's not clear to us that this is compatible with international law. It was sent back to the legislative organ, and the parliament did what the parliament did is very interesting. I think they just erased the final sentence, which said in accordance with international law, put it in its current format that said they can be owned, full stop, and then they passed the law like that. Now this is interesting for many reasons. I don't think we have enough time to talk about all the interesting reasons, but I think the first reason is, of course, it showcases really the controversy surrounding property rights relating to space resources. It's far from granted that this is in accordance with international law, in outer space law, even though there are very proactive initiatives like the Artemis Accords, Title 10, where there are these unilateral declarations that say that space resource extraction activities aren't necessarily against Article 2. And from the perspective of a Luxembourgish company who is, let's say, operating on the moon, sure, it certainly gives a legal certainty vis-a-vis Luxembourg, that Luxembourg would recognize these rights as property rights and as legitimate rights. But this law is, of course, not an answer to what happens when China or Russia or any other entity that does not have a similar law conflicts with that operator, Luxembourgish operator, who is acting on the expectation that Luxembourgish law recognizes this property right. So, perhaps a word of caution here would be that without at least some basis, fundamental understanding on the multilateral level as to whether these activities are legal and to what extent are they legal and in what form and shape are they legal. These legal promises, even though obviously they're valid within the domestic framework, internationally they're far from giving any security without some multilateral consensus at some level. And UN COPOS is an appropriate avenue for this, of course. It's usually criticized for being a little slow in terms of progress, but this does not really change the fact that there has to be some multilateral understanding and agreement so that states can operate, if they will, in the future, without worrying that another state will sort of take away or somehow refuse to recognize these rights. Because when it comes to space resources, if we are to become a spacefaring species, it's not really a question of whether or not we will use the space resources. It's really a matter of how and how we're going to use them and who is going to use them. So law of 2020 is, as I said, it's a more general law. And again, the same thing applies to this image as well. It's the prompt is law of 2020 on space activities. And this is the image that came up. So no space activities can be conducted without the authorization of the Luxembourgish Ministry of Economy, and all operators conducting research space activities, including research activities, from the territory of Luxembourg or from installations under control or within jurisdiction of Luxembourg will have to apply for a license. Luxembourgish natural or legal persons conducting space activities based outside Luxembourg are not within the scope. It has certain critical definitions like what is a space activity, what is a damage, what is a space object, what's an operator, etc. And these operators and the authorization that they have to obtain is mandatory and it's personal. It cannot be transferred without the express approval of the ministry, otherwise they cannot be assigned. And some of the requirements, it's not all requirements, of course, but some of them at least, that in the process of the license application, the operator or the prospective operator needs to show evidence that Luxembourg is the center of their operations, that the central administration and the registered office are in Luxembourg, and they have to provide a robust scheme of financial, technical, statutory procedures, arrangements. There has to be a sound and prudent operation plan, and they all have to be detailed in the way that it's prescribed in the law. There are also more specific, if you will, requirements that there has to be, the operator has to have good repute, it has to have a good reputation from an operational perspective. Also, the shareholders of the company that's applying for this license has to have similarly good repute. Knowledge, skills, experience of any member of the management body is required, and there has to be financial soundness. These are not elaborated very much in the law. There are requirements relating to risk assessment, of course, as is obvious to all of you. I believe risk assessment is an extremely important part of space operations, space activities being extremely risky. So there has to be adequate coverage, either through personal financial means. If you're Elon Musk, that's not a problem. But there has to be a comprehensive insurance policy. There has to be a guarantee via credit institution. Somehow it has to cover. There are certain technical requirements and standard requirements. There are a few things to observe here. I will then quickly conclude. The laws are increasingly perceived to be very burdensome, in particular on smaller entities, SMEs in particular. As I mentioned at the beginning, Luxembourg is a very it's the seeding ground for a lot of startups. If you're a new space company, for example, working on agri-tech, and you have an earth technology that you're developing in agricultural technology, new cutting edge technology, and you want to sort of continue this and apply this technology to space, lunar agriculture, for example, you would technically fall under either law, 2017 law, or the 2020 law. But without enough money and enough know-how and a robust, a good, reputable team, then you wouldn't really be able to get this concession. And there are many companies, many startups that are, in the first and second cycle of their funding, and it's very difficult for many of them to actually demonstrate any of this. So this might, and in certain cases, it certainly is a hindrance for a lot of newer companies to succeed in obtaining a license. Another thing that's missing in the laws, in my opinion, is very important, is that there are no references to environmental impact assessments. It does not really require the operators, when they apply for a license, to give an environmental impact assessment. There are some references to end of life, but there is no explicit mention of environment, which I think is something extremely crucial. In the Finnish law, for example, the recent law, and in the law of the Republic of Cyprus, we see that these are added, and that would be ideal, of course. So, final words. As I said, Luxembourg is I don't know where it would fit on Laszlo's chart, but somewhere in the middle, I suppose, because it has autonomy. Capacity, you would have to really redefine what capacity means. It certainly doesn't have a launching site, doesn't operate autonomously, but it has managed to attract a lot of interesting actors, private actors within its jurisdiction. So I would say that's some form of capacity. That's not necessarily a hardware capacity, but definitely a financial capacity that's present there. It is clearly, to me, it's a hub for commercial space companies and activities in Europe, along with the Ruhr Valley, like Köln, Bonn, Luxembourg. That sort of crescent is a very interesting place to be if you're interested in space. Though it has a very active, responsive, interactive space agency. It's a very small space agency, but they're doing a fantastic job, in my opinion. And one final mention is needed for the European Space Resources Innovation Center. This is a joint initiative by the ESA, Luxembourg's government, and Luxembourg Space Agency. This is a research institution. It's a natural science research institution. They're geologists basically conducting research on how to extract regolith from the moon and turn it into water. And they're also an incubation program. They actually provide initial funding for the startups specifically working on space resources. And the final lingering, persistent question is then, despite this relatively comprehensive national framework, there are persisting questions relating to their compatibility with international law, and I think I will leave it at that. Thank you very much.